Hello everyone, it's Wayne Jones, the course coordinator for Statutory Interpretation. These are my comments on things to look out for in the Week 8 material, which deals with the Extrinsic Materials. This is dealt with in Chapter 8 in the textbook by Michelle Sanson, Statutory Interpretation. And of course, extrinsic materials are different from what we've talked about over the last 2 weeks. Intrinsic materials, the things that are in the Act themselves, and we talked about things like the words, the context, so the words around the surrounding paragraphs, etc. And so far as intrinsic was concerned, we also talked about the way the Act was set out. So this is extrinsic. You've set aside the piece of legislation now, and you're thinking about whether you can look at legislation which appears outside. And there is in fact a statutory basis for being able to do this. Here's a short extract from section 15AB from the Commonwealth Act, which talks about extrinsic material being able to be used, for example, to try and ascertain the meaning of the legislation. To confirm that the meaning is in fact the ordinary meaning is one example that's given in section 15AB. To determine the meaning when the provision is ambiguous or obscure, or if the ordinary meaning leads to a result that's manifestly absurd or unreasonable. Now, the textbook author asks you to think about whether or not confirming is the same as identifying whether or determining if, etc. And of course, there are some limitations that are acknowledged, even though the legislation itself says you can have a look at extrinsic material. And they've been suggested in the couple of cases I've mentioned here. In Mills and Meeking, for example, the court came down fairly clearly saying if the language is pretty clear and it matches the purpose, there will be no need to use extrinsic material. Likewise, in the case of Catlow and Accident Compensation Commission, the courts said if the meaning is plain, extrinsic materials really don't have a place, they don't have a purpose. So what is the modern approach? Well, there is a suggestion, so notwithstanding that view that if the language is clear, if the meaning's plain, etc., there mightn't be much work for extrinsic material to do. There is a suggestion that the modern approach to statutory interpretation is to consider context in the first instance. So not when you run into problems, but every time you look at a piece of legislation, you should consider its context. And context has been suggested to be used in the widest possible terms, and that's referred to in CIC Insurance and Bankstown Football Club. So fairly broad context, that includes, for example, history and the history of the legislation itself, but it's also been held to include, context has been held to include extrinsic materials. So have a look at that case. It is, after all, a basic rule of statutory construction to give effect to the text, but in the light of context and purpose. So if you think about that last slide about whether meaning is plain, language is fairly clear, etc., it's still the situation that you can have a look at and consider context. What was the old common law approach? Well, interesting. The common law took the view that historically the courts would make little or no reference to extrinsic material. Remember, right at the very beginning of this subject, we talked about some of the old cases that dealt very much in the world of the literal. So they just, cases like the engineer's case that simply said, look, the words are there, they're black and white, we think you should give them their literal meaning. So the courts really only used extrinsic material as a last resort after they'd looked at every other possibility. So that was the old common law approach. The interpretation legislation itself talks about what material can be used. So have a look at section 15AB2, fairly comprehensive list, but you're going to see in that list some of the things that I've asked you to look at already, and they are the explanatory memorandum that accompanies the bill into the Parliament, and also include the second reading speech itself. So have a look at that list for yourself and see what it's got to say. The explanatory memo and Hansard can usually be accessed at the government site in your particular state, which deals with legislation, and of course you can search through Hansard for second reading speeches. But consider those two as probably the most popular, along with, of course, a dictionary. People tend to forget that a court can have a look at a dictionary. What's excluded? Need to think about this one. Policy documents that are made after the event, delegated legislation, so regulations, that sort of thing, and comments made by ministers after the legislation's passed. So what's the thinking behind those three exclusions? Well, it's probably fairly obvious. All of those documents came into existence after the legislation's been created. So using the rules that we've talked about already around whether or not Parliament had turned its mind to something, or what could have been on Parliament's mind at the time the legislation was made. Clearly things that happen after the event are not going to affect the Parliament, and so they can't be taken into account. What's some of the other limitations? Well, have a look at in the Re Bolton ex parte Bean case. That was the one where the fellow deserted from the army. The speech that was given by the minister who introduced the legislation which was being looked at is arguably much more extensive in its operation than the words of the Act which come out the other end of the process. So if the speech is at odds with the words in the legislation, extrinsic material can't redeem a failure to translate that intention, so what the minister is saying, and it can only go so far. And that's exactly what happened in Re Bolton ex parte Bean. The court just said, look, that might have been what the minister intended, but the words don't meet that intent, and we can only work with the words. Note also in the textbook the reference to the case Lacey, the Attorney General of Queensland, where the judge in that case, I think, used words along the lines of there was now an excessive recourse to second reading speeches and extrinsic materials. So it was happening too often in the view of that judge. But is it in fact now the expected approach? Because to counter that approach, the textbook refers to a comment by Justice Kirby that suggests that it's probably now something that happens in most cases. So, as usual, nowadays, the court was taken to the second reading speech by counsel. So, your job as a solicitor or barrister appearing for a client in an interpretation issue will be to make sure you try and get in the extrinsic material, like second reading speeches, like the memorandum of that accompanied the bill, if they support your case. And here's Justice Kirby saying, well, as usual, that's the sort of thing that happens. What are some of the limitations? Well, the authors refer to the fact that even section 15 itself, the language uses words like, well, you can be used to confirm the ordinary meaning if it's ambiguous or obscure, or if it comes up with a manifestly unreasonable result. And then you've also got section 15AB3 that gives a further analysis of when you can use material from outside of the legislation. And it says that the courts really need to consider the desirability of the public being able to rely on the ordinary meaning of the words that they see before them in the Act, and that there needs to be a need to avoid prolonged legal proceedings without any advantage. I guess what that section says to me is that the legislature accepted that there'll always be cases on statutory interpretation, but they didn't want to open another doorway to say, well, if you're not having much luck, by all means think about bringing forward some additional extrinsic material, and maybe that you can raise an argument that way. It's still meant to be part of the interpretation process, not a whole other way of approaching statutory interpretation. I think one of the interesting cases for me from this chapter dealt with the idea that extrinsic material could be more than just the explanatory memo and the second reading speech, etc. It could be looking at the legislative history. So what are the changes that have happened in the Act and why? And even some of the cases which sat behind the changes. So the case I'm talking about is Insurance Commissioner of Western Australia against container handlers. And you might remember this one from your reading. This was the one where the man badly injured his hand jacking up a truck, which had been driven but was no longer being driven. And the question was, for a Queensland lawyer like me, it was similar to the Queensland legislation which talks about third-party insurance being there for accidents caused by, through or in connection with a motor vehicle accident. Pretty wide open door. In Western Australia, as you saw from the case reading, there had been a case where a young child playing with matches and then burned in a car was able to claim under the third-party insurance. And the court said in that case, well, really the only connection here to a car is that the child was sitting in a car. So, but nevertheless, that's how the Act reads, so we're going to give the child some compensation. So that case then prompted the legislation to change, or the legislators to change the legislation, and they said, well, we're going to have to address this issue in the second reading speech. The Minister, and in the explanatory memo, the Minister explained that this case would indicate that the floodgates were going to open, all sorts of matters would be brought before the courts as a claim if they didn't close the gap. So they made a change. The old version of the legislation used these words: bodily injury to any person caused by or arising out of the use of such motor vehicle. And it became, these words, directly caused by or by the driving of the motor vehicle. And then there was an additional definition added in section 3.7, driving shall not be taken to have been caused by a vehicle if it's not a consequence of the driving of the vehicle or of the vehicle running out of control. So there was this whole change in emphasis towards cars running, driving, moving, a moving vehicle, in other words, the more standard concept of a motor car accident, other than kids setting fire to themselves with matches in a car. And so when it came up for interpretation, the courts didn't have much problem. They said, well, look, we're going to consider, in trying to work out what the legislation means, we're going to consider that previous case I mentioned before, the one with the matches. We're going to consider what the Minister said when the bill came before the Parliament, and then we're going to look at how the Act used to look and how it looks now. And all of those things which are outside of the words of the legislation itself, all of those extrinsic things we're going to take into account. And that's how they arrived at their decision. So I thought that Insurance Commissioner case was interesting from that perspective, because it really made plain that there's lots of things that could fall under the umbrella of extrinsic material. Look, finally, just cases themselves as extrinsic material. Take note of the fact that unless a court decision is about exactly the same words from exactly the same Act, then they can't be binding on another court. And I think I gave an example in one of the seminars that defining a road in mining legislation, for example, when that happens in a court, that's not going to form a precedent that'll be binding on another court that's being asked what a road means, say for the purpose of seatbelt legislation. Car driving on a road, referring to a road there, that might be a very different meaning to the use of the word road in mining legislation, because of that whole business about context. So just be aware of that. Unless it's exactly the same words in exactly the same act, then cases can't be referred to bind a new court to make a decision about those same words in the same way. Cases which consider the overall purpose of the Act, so if a superior court talks about what the purpose of the legislation is, you can certainly put that forward as part of your argument. Whether two acts are interconnected, I've given you an example there of maybe tax legislation, and it might be read in conjunction with a separate piece of new legislation dealing with, say, capital gains tax, or might deal with some other form of minor tax legislation. Words around an interconnected series of acts are usually given the same sort of meaning. And the best example I can think of perhaps would be what is a deduction in one type of tax law is probably going to have a similar meaning in another type. And also where words are part of a legislative scheme. And again, the best example I can think of there would be the states at the moment are trying to introduce fairly uniform workplace health and safety laws. And so, just to make something up, perhaps if there was a court ruling on what the word accident meant in Queensland, then that would be a very great persuasive value if the same word came up in New South Wales in similar legislation, because it's part of a legislative scheme, and of course it's in the public interest that if you've got workplace health and safety laws throughout Australia, even though they're state-based, it's in the public interest that the legislation is understood in a fairly uniform way across the different states. So that's my comments on that week, on week 8, Extrinsic Material. I thought it was a pretty interesting read, and certainly after reading that, you'll have a better idea of what is extrinsic material. When can you use it? What are the limitations? And what are some of the likely effects? So I hope you enjoyed the reading.